Buongiorno a tutti. Good morning, everybody. Good morning, colleagues. Welcome back to the second day of the event around International Fair Trial Day. And I'm honored to be here and open this session, the second day, and representing the IBARI, the International Bar Association's Human Rights Institute. Let me first thank once again the Palermo Bar for hosting this event. Today, we will rather focus on the international perspectives and standards in terms of development, challenges, and good practices in relation to fair trial and fair trial rights and issues. We will have now an opening session with a video message from the UN Special Rapporteur on Human Rights Defenders, Miss Mary Lawlor, and a keynote from Professor Philippa Webb, followed by a panel of distinguished experts on fair trial. And then the Ebru Timtik Award ceremony will close this 2 days event. Yesterday, we discussed concrete issues related to the situation in Egypt. We had a deep dive into Egypt. One specific sentence that struck me was, if I'm not mistaken, was from Bahei, the director of the Cairo Institute for Human Rights Studies, where he stated that trials in Egypt do not follow the due process. They look rather like a show. So Egypt, as we all know, it's not an isolated case. We can witness every day systematically similar cases around the world, from the global north to the global south. In 2021, the report of the UN Secretary General, Our Common Agenda, in that report, the Secretary General mentions and states that justice is an essential dimension of the social contract. Just to give one example, according to the UN estimates, the proportion of prisoners held in detention without sentencing, most of time in prolonged detention, has remained almost constant in the last decade, amounting to 31% of the entire prisoners' population. This is, of course, in breach of the international standards on fair trial that, as we all know, is an internationally recognized fundamental right, including by virtue of Article 14 of the International Covenant on Civil and Political Rights. Just worthwhile recalling the interpretation of the Human Rights Committee in its general comment number 32, stating that deviating from the fundamental principles of fair trial, including the presumption of innocence, is prohibited at all times. There was another sentence that yesterday struck me, always from Bahei, when he stated rightly that the independence of the judiciary is the first line of defense for human rights. And this has reminded me that while we're here in Palermo, the 50th session of the UN Human Rights Council has started this week, last Monday, on Monday. And during this session, there will be a specific report on the table for negotiations. Actually, negotiations will start on next Tuesday on a resolution on the independence and the integrity of the judiciary and the protection of legal professions. But equally important, it is during this session of the Human Rights Council, there is the presentation of the UN Special Rapporteur on the independence of judges and lawyers, Mr. Diego Garcia Sayan, who will present his report on the protection of lawyers against undue interference in the free and independent exercise of the legal professions, where he states one by one, according to the information that he has received, all these challenges and the attacks against lawyers that are simply for performing their duties, their professional duties. And the report also explicitly recalls that the free exercise of the legal profession is an indispensable element of the judicial guarantees that ensures a fair trial and the protection of all human rights. Now, without further ado, I'm honored to transmit the video message from Ms. Mary Lawlor, the UN Special Rapporteur of Human Rights Defenders. Ms. Mary Lawlor does not really need an introduction, but she took up the mandate as special rapporteur on the 1st of May 2020. She has worked extensively with and on the situation of human rights defenders. And since in 2001, she founded the NGO Frontline Defenders. So let's hear from Ms. Mary Lawlor now.
Thank you for inviting me to speak to you today. And I'm sorry I'm not there with you in Palermo to meet you all and all of you who've been organising the conference. But unfortunately, this is the time when I am soon to go on my first country visit after the lockdown of COVID, and it clashes with the meeting. My last report to the General Assembly in October focused on the issue of human rights defenders sentenced or liable to be sentenced to over 10 years or more in detention. It is an issue that's a priority for me. Defenders are jailed for very long terms, often on. Thank you for inviting me to speak to you today. I'm sorry I'm not there with you in Palermo to meet you all and all of you who've been organising the conference. But unfortunately, this is the time when I'm soon to go on my first country visit after the lockdown of COVID, and it clashes with the meeting. My last report to the General Assembly in October focused on the issue of human rights defenders sentenced or liable to be sentenced to over 10 years or more in detention. It is an issue that's a priority for me. Defenders are jailed for very long terms, often on the pretext of national security or anti-terrorism legislation and after unfair trials. We see this across the world, not just in one country or one continent, and it's not a new issue. In researching my report, I noted that since the mandate was created more than 20 years ago, it has consistently raised the problem of defenders subjected to unfair trials. Hina Jalali, the first person to hold the post in our very first report to the then Commission on Human Rights, said the situation of human rights defenders and their sentencing after unfair trials will be a matter of serious concern for the special representative. And so it continues to be, because states still subject defenders to sham trials that fall far short of international human rights standards. Despite regular detailed updates to UN member states from the Special Rapporteur on Human Rights Defenders over many years about this unjust practice, defenders are still routinely subjected to unfair trials, after which many are sentenced to very long terms. We know that many judges and lawyers who are targeted for their work in advocating for the rights of defendants, and sometimes they themselves end up in prison as a human rights defender. Rights to be common in many countries, including Egypt, and I have taken up the cases of many defenders in Egypt, some of whom are with you today. Many have been put into pre-trial detention, and if they eventually are given a trial, it is likely to be unfair. When I raised the issue of unfair trials with state officials, some tell me that they can't interfere in their country's independent judicial systems. I understand that, and I respect the principle of judicial independence, but I cannot and will not be silent when a criminal justice system falls short of international standards and is used to unjustly jail human rights defenders. Silence in the face of unfair trials encourages and enables the practice. And here I would like to address the issue of silent trial observers representing other governments. As always, the decision about whether a government should trial of a human rights defender with the consent of the defender, and at the request of the defender, I recommend the representative of the government observing the trial should also state publicly if, in their view, the trial has not met international standards. The current diplomatic etiquette is that by sending a representative to observe the trial, embassies and other government officials are sending a message to the court that they are monitoring the process. While that in itself can be useful, it can sometimes be taken as acquiescence to an unfair process. If an observer sees that the defender on trial shows signs of torture, or there is some other clear indication that the trial is unfair, they should publicly declare that immediately. Embassies, with the consent of the defender, should adopt a policy of see something, say something, if they are witness to the human rights violation of an unfair trial. Year after year, decade after decade, the Special Rapporteur for Human Rights Defenders have complained to the UN about unfair trials for defenders, but it still happens. Those seeking this practice should call it out, and be very clear about it, and be supportive for doing so. I wish I could be here with you today, and I look forward to hearing the outcome of your discussion, and I wish you well for your conference.
So we thanked also the Special Rapporteur for this video message, and the Special Rapporteur touched upon some very specific issues and very equally important. First, when states strategically appeal to the judicial independence in order to avoid or in order to condone violations of fair trial rights. And secondly, she touches upon the problem of silent trial observers. We will hear more about general fair trial guarantees, challenges and trends, but on the importance, in particular, of trial observations from Professor Philippa Webb in her keynote speech. Professor Philippa Webb is a professor of public international law at King's College London and a barrister at 20 Essex Chamber. She's a specialist in public international law and a leading scholar in human rights, including the right to fair trial. Among others, she's a board member of the Clooney Foundation for Justice. Philippa has held the positions in the presidency of the International Court of Justice, the Office of the Prosecutors of the International Criminal Court, and in the United Nations headquarters. Her publication include the most recent, the right to a fair trial in international law that has been awarded the American Society of International Law Certificate of Merit. Professor Webb, you have the floor. Thank you.
It is an honor to address you today on International Fair Trial Day, and I congratulate the steering group on their initiative to increase awareness of this fundamental human right, including by having a photo this year. This morning, I'm going to cover 3 topics. First, I'm going to give you the big picture. The right to a fair trial is the most litigated, yet the most elusive human right. Second, I'm going to outline the main components of the right in international and regional instruments. And then third, as Francesca said, I'm going to highlight the importance of trial monitoring, drawing on the experience of the Trial Watch program of the Clooney Foundation for Justice that has been monitoring trials in 35 states, including Egypt, since 2019. So first, the right to a fair trial is the most litigated human right in the world before international bodies. More than half the cases filed before the Human Rights Committee concern the right to a fair trial. And at the European Court of Human Rights, 49% of cases involve fair trial violations. That is more than double the number of cases that invoke any other human right. And just in the last 6 months, there have been 100 more Article 6 European Convention cases. Fair trials are a precondition for and a symptom of a well-functioning democracy. Whereas, as we've heard from Mary Lawler, an undemocratic system will use the courts to protect power, to silence critics, and to intimidate citizens. But the right to a fair trial is increasingly elusive. The University of Gothenburg reports that there are more autocracies than democracies today. Freedom House says that over the last year, 18 states have had a decline in democracy. And this was the 17th consecutive year of decline. Egypt is characterized as not free by Freedom House and scores only 18 out of 100 for its respect for civil and political rights, including the fair trial right. And the pandemic has worsened what was already fragile fair trial practices in various states, including through potential breaches of the right to be present, the right to have adequate facilities to prepare a defense, and to be tried without undue delay. We can also identify systemic problems through conviction rates. In a well-functioning system, you would expect there to be some acquittals, especially with full respect for fair trial rights. But the conviction rate in many states is extremely high. In Japan, it's 99%. In Russia, it's 99.5%. In the United States, it is 90%, with more than 97% of convictions not even going to trial, but arising from a plea deal. And Egypt's military courts have a conviction rate of 93%. So that's on the systemic level, but we also see the elusive nature of the right to a fair trial in individual cases. In Russia, opposition leader Alexei Navalny is in prison for probation violations. 5 years ago, the European Court found that his trial in Russia for financial crimes was arbitrary and manifestly unfair. But Russia keeps trying and convicting him. Just in March of this year, he was sentenced to another 9 years in prison on fraud charges. Amnesty International has condemned the trial as a sham. The trial was in fact held in a maximum security prison, not in a courtroom, and it was not clear how witnesses, the public, journalists, or even his defense team could attend the facility. I now turn to my second point, the right to a fair trial in international and regional instruments. The right to a fair trial was recognized in the Universal Declaration of Human Rights in 1948. And since then, it has been included in all international and regional human rights instruments. We know the International Covenant on Civil and Political Rights from 1966 is the leading text in this regard. It has 173 states parties from every region of the world. And even states that are not party to the ICCPR have codified fair trial rights in their constitutions, such as China, Saudi Arabia, and the UAE. So the fair trial provision of the ICCPR is Article 14, and I'm going to keep coming back to this article. It has served as the model for fair trial rights in the treaties concluded by Europe, the Americas, Africa, and the Arab region, as well as the Human Rights Declaration adopted by the Association of Southeast Asian States. Article 14 has also provided the foundation for fair trial rights in the statutes of international criminal courts. We also see fair trial rights in the Convention on the Rights of the Child, the Migrant Workers Convention, the additional protocols to the Geneva Conventions. And there are many other international instruments that relate to the right to a fair trial or a specific aspect of that right. We have the UN Basic Principles on the independence of the judiciary. And we heard from Francesca that Judicial independence is a focus of the Human Rights Council at the moment. We have the guidelines on the role of prosecutors and the UN Basic Principles on the role of lawyers. Let's take a closer look at Article 14 of the ICCPR, because it can be broken down into 13 component rights that together make up a fair trial. The first one is the right to a competent, independent, and impartial tribunal established by law. There is then the right to a public trial, to the presumption of innocence, the right to prepare a defense, the right to counsel, the right to be tried without undue delay, the right to be present, the right to examine witnesses, the right to an interpreter, the right to silence, the right to appeal, the right to equality before the courts, and the right not to be subject to double jeopardy. All of these make up a fair trial. There has been little analysis of the degree to which these components and the overall right have achieved customary status. So that was something that we tried to do in our book, look through all the materials and sources to establish whether this is a customary right over and above its existence in treaties. And we found strong evidence that the right as a whole is customary, as well as most of the 13 component rights. And we also found confirmation that the overall right and most of the component rights are non-derogable, even in a state of emergency. So even though the right to a fair trial is not included in the list of non-derogable rights in the ICCPR, the Human Rights Committee has said that states parties may in no circumstances invoke derogations as a justification for acting in violation of peremptory norms of international law, including deviating from the fundamental principles of a fair trial. The Inter-American Commission has said that the right to due process and fair trial must be respected even in an emergency. The African Commission does not permit derogation from any right in the African Charter. And the Arab Charter also says the right to a fair trial is non-derogable. So I now turn to a few words on trial monitoring. As we have seen, the international standards for a fair trial are well developed in all of these various instruments, and especially in Article 14, and they're also widely accepted. But the next question is, what is happening on the ground? How are these rights being implemented in practice? And trial monitoring can give us an insight and also a tool for looking at the implementation and the improvement of the implementation of fair trial rights. Trial monitoring can have an impact throughout the life of a case. The monitor's mere presence in the courtroom may make a positive difference. And I know Mary Lawler has also given a perspective on this. From the Trial Watch program's experience, in the trial of Ahmed Mansari, an Algerian blogger charged with criminal defamation for reporting an assault by the police, his trial had a Trial Watch monitor present. And the monitor reported that the case was treated very differently from other cases being heard in court on the same day. The case was given more time, he was able to speak properly to his counsel, and he ended up being acquitted. During and after a trial, monitoring and reporting can provide objective data and an expert assessment of what happened. And after the trial, the monitoring report can provide a basis for pursuing remedies for individuals whose rights have been violated, and also to support systemic change. And I want to share some examples of positive impact from trial monitoring. In Cambodia, a journalist, Ros Soket, was charged with incitement to disrupt social order based on Facebook posts that were critical of the Cambodian Prime Minister. Trial Watch monitored the trial, found that it had some breaches of Ros Soket's fair trial rights, And that provided a basis for a filing before the UN Working Group on Arbitrary Detention. The UN Working Group found that indeed Rossakev was arbitrarily detained and there had been fair trial violations, and they were released shortly afterwards. Russia has been cracking down on Crimean Tatar activists, including Server Mustafayev, who was tried for terrorism by a Russian military court and convicted and sentenced to 14 years in prison. Trial Watch monitored the trial, made a report and a filing before the UN Working Group. And the working group was able to render specific findings, finding that there was a serious denial of equality of arms in the proceedings and a failure to act in an impartial manner. In other cases, Trial Watch findings have had an impact on domestic proceedings. In Malaysia, after a report on proceedings against a blogger charged with statements that might cause fear or unrest to the public, the prosecution offered to settle the case for a fine. And when Ugandan women's rights activist Dr. Stella Nyanzi was convicted for posting a poem critical of the Ugandan president on Facebook, the Trial Watch report on her case was submitted to the Ugandan appeals court by her legal team, and her conviction was overturned on appeal, in part because of the violations identified in the trial monitoring report. So I just want to conclude with some recommendations for going forward. And my takeaway message is we have to be perceptive and strategic in protecting the right to a fair trial. First, perceptive. The first component right listed in Article 14 and also in the list of component rights I gave you is to an independent tribunal. And this is arguably the most important component right. You might have all the other 12 component rights respected. You may have an interpreter, you may have a counsel, you may be able to appeal, but without an independent judiciary, your trial will be unfair. And the recent speech by Mary Lawler and the reference to the show trials in Egypt illustrate the importance of this component right. If there is a suspected politicized prosecution, we have to be perceptive in not only monitoring the trial, but reviewing the law under which the person is charged, assessing the evidence relied on to convict, and also looking more broadly at patterns of prosecution. So for instance, in the trial of the Ugandan activist, Dr. Nyanzi, the charge was under the Computer Misuse Act. And when you have a look at the pattern of prosecutions under that act, you can see it is being used by the Ugandan presidency to pursue criminal penalties, to silence dissent and to stop democratic criticism. We also have to bear in mind the impact of violations that occur both before and after a trial. The impact of lengthy pre-trial detention can lead to trials with undue delay or inadequate facilities to prepare a defense, or even the ability to choose and instruct counsel. We also have to be perceptive that emergencies, including the pandemic, have been used as a pretext for restricting fair trial rights to a greater extent and for a longer period than could ever be justified. And my second point is we have to be strategic. We should be using trial monitoring with the awareness of how it can have a positive impact at different stages, both before, during, and after the trial. We should pursue accountability for individual cases of unfair trials, but also look for opportunities for more systemic change, and also looking at how the right to a fair trial interacts with other human rights that are being abused, such as freedom of expression. And finally, we have to understand that the remedies available under different international mechanisms have to be tailored to the particular case. Is the client seeking release, in which case some international bodies may be more effective than others? Is it about awareness raising? Is it about compensation? Is it about trying to get some legislative or constitutional change? All of these will be strategic considerations for tailoring our action to protect and promote this most fundamental human right. Thank you.
Thank you very much, Filippa, for walking us through first of all, for recalling that pre-trial is a precondition of a well-functioning of democracies, but also to emphasizing the elusive nature of fair trial rights, for walking us through the 13 elements of fair trial rights, and was also very interested how you very clearly explained us how these rights are then implemented in practice with some examples, encouraging examples of the impact of fair trial rights in the field directly. Also, thanks for giving us these insightful recommendations. Professor Webb will remain with us during the next panel for answering any questions. Let me just close this session by quoting Martin Luther King, that injustice anywhere is a threat to justice everywhere. With this, I leave the floor to my colleague Jacqueline Scott to moderate the next panel. Thank you.
Good morning, everyone. Can everyone hear? Great. As we saw and heard yesterday, our colleagues in Egypt have been subjected to every possible violation of human rights and every possible violation of the right to fair trial. Today, we are, as Francesca noted, we are going to discuss the international implications to the international community and some of the things that the international community can do to address the situation. Today with me, we have an illustrious panel, and I'm honored to moderate this panel of experts, international experts on this topic. I think we still have Philippa Webb on the screen. I'm going to pull that up. Thank you, Philippa, for joining us and agreeing to, and you all have heard the many accomplishments which she has. Great. Now I'd like to introduce the rest of our panel. We have Baroness Helena Kennedy, QC, one of Britain's most distinguished lawyers. She has spent her professional life giving voice to those who have least power within the system, championing civil liberties and promoting human rights. And she's used many public platforms, including the House of Lords, to which she was elected in 1997, to argue with passion, wit, and humanity for social justice. She has also written and broadcast on a wide range of issues, from medical negligence to terrorism to the rights of women and children. Baroness Kennedy, we're delighted to have you join us. Welcome. To my left, Giuseppe Anconcio, an award-winning journalist and researcher who focuses on the Middle East. He has been a researcher at the University of Padova, a visiting scholar at the University of California, UCLA, a teaching assistant at Bocconi, and a lecturer at the Cattolica University in Milan. His research focuses on youth and social movements, Iranian domestic policies, and the state and transformation in the Middle East. He's the author of a great number of writings, publishing in Il Mulino, the International Spectator, the Carnegie Endowment for International Peace, and Palgrave. Welcome, Giuseppe. To my left, Faiz Bernarbia, who leads the ICJ, International Commission of Jurists, research, advocacy, and litigation work in the Middle East region. For the past 18 years, he has designed and implemented strategic initiatives on the applicability of international humanitarian and human rights laws during armed conflicts, justice, and rule of law reform, accountability for serious crimes under international law, women's access to justice, combating impunity for sexual and gender-based violence, and human rights and counterterrorism measures. He's previously served as a legal officer, legal advisor, and senior legal advisor for the ICJ MENA program. He also worked in the International Law and Legal Department of the International Organization for Migration. Saeed holds a degree in international law from Fez University, Morocco, an LLM in public law from the Bourgogne University in France, and an LLM in European law and studies from the University of Geneva, Switzerland. So without further ado, why don't we turn our attention to the international implications of this right to fair trial. Why don't we start with Baroness Kennedy? If you would share your thoughts on this, I would appreciate it.
Well, let me do that. I'd like to echo that it's a great privilege to be with you, but I think there is an actual echo. I hope that it can be tuned out. This is a really important conference because unfortunately, the spread of authoritarian governments has been another pandemic in our midst, along with the COVID-19 pandemic. We've seen a great increase in populist governments coming to power and abusing their power in order to sustain it. And one of the first ways that people do this, almost invariably, is to silence opponents, find ways of doing that, often by abusing what law that already exists, and indeed capturing the judiciary frequently by either intimidation, by reappointments under the guise of reform. And a captured judiciary is not an independent and unbiased judiciary. And so, of course, the will of the president, prime minister, or whoever's in power is what tends to guide the performance of the court. And so we have seen this. I am the director of the International Bar Association's Human Rights Institute. And one of our great roles in all of this is to have oversight of what is happening in countries around the world. We have 186 bar associations under the umbrella of the IBA, and the Human Rights Institute, it monitors for human rights abuses and tries to stir into action bar associations to resist ways in which there is this abuse takes place. Now, I'm going to just mention a number of the areas where we've been doing particular work recently. I wanted to echo what our keynote speaker, Professor Webb, said about how fundamental fair trial processes are in any democracy. And also to pay tribute to her and to Amal Clooney, who have really produced for us a really wonderful book, which I recommend to everybody, The Right to a Fair Trial in International Law. But it really is the right to a fair trial generally, because all the principles that apply relate to national jurisdictions too, and the ways in which these principles should be applied everywhere that someone is at risk of losing liberty or suffering a detriment, and indeed sometimes losing their life. So let me just, I should also tell you that this book, no book had been written, no comprehensive authoritative book had been written before Philippa Webb and Amal Clooney wrote this great book. I recommend it to you all because it really is the Bible on fair trial rights. Now, we've created a fair trial day in our international legal firmament and in the human rights world. And of course, it's on the 14th of June and we're coming to it slightly late. But that's what we're here to both celebrate and also to draw attention of the world to the failures to protect fair trial. I was involved over the last few years in what's been happening. Let me just close my door, forgive me. Life intervenes in one's professional purposes. That's my grandchildren arriving at my home. And one of the things that we've been monitoring is our fair trials. And as Philippa Webb was saying, an important thing for the legal world and indeed for human rights defenders to be really conscious of is the importance of having trial monitoring. Because it can make a difference to the outcomes. Regrettably, we're seeing an increase in the failure to allow observations to take place. And I was going to mention that in Turkey, where the award that has been created for International Fair Trial Day, the Ebru Timtik award, related to young lawyers who in fact were imprisoned for acting for people who had been critics of the state and who in turn ended up in prison themselves. And they had gone on hunger strike. And of course, as you know, Ebru Timtik died in prison, having gone on hunger strike against the regime's refusal to abide by the rule of law. And so we're seeing increasingly in many places where the claim is made to democracy, but where authoritarianism is essentially the way in which the government is being run. And inevitably authoritarianism involves attacks upon the rule of law, fair trial processes, and the use of new laws or even existing laws, but in a way in which, as Philippa Webb was saying, is directed towards particular groups, and it's extinguishing the voice of opposition or critique, and sometimes the voice of those exposing corruption. Now, let me just talk about totalitarian regimes. We don't expect much when there is a totalitarian regime, one that has no claims to democracy. We know, I mean, for example, after the Jamal Khashoggi assassination in Turkey by the Saudi regime's an active force that was sent to do that criminal work. The people who were identified as having been involved in his killing, it was claimed were put on trial in Saudi Arabia. We made an effort to wrote to the king and to Prince bin Salman, that we wrote asking that we might have a presence in the court for that trial because it was so important to the world that they saw that justice was done. We had no success in that. There's no access to courts in Saudi Arabia. And for that court case, because of the pressure that was applied, they eventually agreed that members of the embassies of the sort of Security Council nations could have someone present in the court, but they were forced to sign non-disclosure agreements so that they couldn't tell the world what they saw when they were in there watching the trial. And of course, they were probably not lawyers and didn't have the benefit of Professor Webb's great book setting out what the principles are of a fair trial in order to see how blatantly there was a corruption of that notion. And so we have no idea what happened within those closed doors. And the same has recently happened in Myanmar. Many people have been put on trial in Myanmar. COVID has provided a protection to many states to keep out observers and to limit and make impossible the use of surrogates to enter the court and to give a report, which can then be assessed by lawyers who are operating externally. No one was allowed into Myanmar for those many trials. Many people, we've seen the execution, just so that everyone knows, we've seen the execution of 114 people have been put to death now under martial law, including leading opposition figures who themselves were not involved in violent insurrection, who were defending their communities and who were simply protesting what the military were doing. And they're now, as I've said, they've been sentenced to death. And executions have already taken place. Many of them, 41 of those sentences have been passed with people in absentia because they fled for their lives, knowing that they were likely to face that. We've also seen that Aung San Suu Kyi and the president of Myanmar were put on trial. That was a trial that we did monitor from a distance, and but drawing to it, and the report will come out shortly. But again, I asked for the live streaming because we were not allowed to go in. The International Bar Association's Institute of Human Rights couldn't get access. And we suggested that perhaps even they allowed in members of the embassies. That also was not allowed. And I asked for the live streaming of the case, but didn't receive a reply to that particular request. So we know that this is how totalitarian regimes operate. But the alarming thing is the spread of these erosions into places that have called themselves democracies. And as our keynote speaker pointed out, that one of the essential elements in all of this has to be about having independent judges, a judiciary that is free from pressure, and free from pressure which is both direct or that they're not appointed because they are favorites of the administration. Unfortunately, something we're seeing in the American system. But what we're seeing in other places is that the chilling effect where judges fear for the consequences of not doing the bidding of those in power operates all the time. And we see that certainly in Russia, but one of the places where the capture has been complete is Belarus. And let me just tell you about Belarus. Again, it's a country where we've been very actively, the IBA has been very actively involved because so many people were arrested after the election. And again, it wasn't just the protesters who were arrested and then the leaders who were sentenced and have been tortured and ill-treated, but lawyers were arrested. Lawyers have been stripped of their practicing certificates. So this business of being able to have representation in the courts has been greatly limited. But the other thing that has happened is the increasing use of the death penalty and introduction of death penalty in situations where, as we all know, capital punishment is supposed to be only available for non-lethal and shouldn't be used for vaguely defined crimes. But we're seeing, for example, in Belarus, that they've now introduced it for, just recently, an amendment to the Criminal Code of Belarus to expand the application of the death penalty simply for non-lethal acts of sabotage, for example, of Belarusian railways that are carrying to obstruct military supplies to the Russian forces in Ukraine. And so demonstrators had done that, and now they're facing the death penalty because of this new change to the law. It's right that yesterday was devoted to Egypt, which has been really a place in which we've seen horrifying things, but the West has been very happy to be close up and cozy with the government there for many different reasons. But according to Human Rights Watch and Amnesty International, we're actually now seeing increases in the use of the death penalty. When I was the head of an Oxford college, which I did for a number of years, one of the young women at Oxford received the death penalty passed on her in her absence, simply because she'd had her first job after graduating in the press office of the last government. In no way involved in criminal activity, but simply having been employed by the previous administration was good enough, and the conviction happened in her absence. She's now, of course, in permanent exile and can't see her own family. I don't want to take up more time because I know that the panel want to speak, but this is a fundamental right. It is the way in which a nation displays whether it really is committed to the rule of law. And as we know, the rule of law is fundamental to a democracy. And not having open courts, public hearings, people able to come in and watch trials is about, of course, not allowing the public to know what is going on. And that whole business of closing down criticism, closing down the media is again part and parcel of in the rise of authoritarianism globally. So let's not pretend that we're seeing something that only happens in totalitarian regimes. It's happening increasingly in places that call themselves democracies, but are excising the word liberal in front of that. Liberal democracy doesn't mean, being liberal about political policies. It means government for everyone. And that means not excluding or being punitive towards those whom you see as the other or whom you see as being critics of what you're doing. And I wanted finally to mention what's been happening. We're mindful of what happens in China, but what has been happening in Hong Kong should be another source of alarm to us, because under the suggestion of a system that is complying with fair trial processes. In fact, very unfair uses of the law. It's as Philippa Webb was saying, you have to look at what is happening and how law is being used and how the new national security law is being used against particular people in particular ways. And by looking at that, you can see what is happening and where the power actually lies in the system and how it is a corruption of the rule of law. And it's a source of sadness to the world, I would have thought, to see that happening in a place that was once democratic. So I really want to call on lawyers everywhere and human rights activists to see this as being at the heart of the work that we do. Because we know that what happens to people who are human rights activists, who are critics of regimes, is that they almost invariably end up at the receiving end of punitive systems of law. And we have to be calling it out. And as lawyers, we have to find ways in which we can be active in stopping this. And by volunteering to be observers at trials, to playing a part in reviewing trials where they're taking place, and to use our expertise to stop these abuses taking place. Thank you for inviting me to be here today.
Comments? As your comments we demonstrate the rule of law, and particularly the right to a fair trial, is increasingly under attack across the globe, and no democracy is completely immune from such things. Of course, the lawyers have a special role in that. We are perhaps the beginning, the media and the lawyers. And of course, it is very important that we have an independent legal profession and independent bar associations, of course, and an independent judiciary. And so I'd like to turn to Saeed now to talk to us a little bit about the right to fair trial from a judicial perspective.
Thank you, Jacqueline. We'll talk about the role of the judiciary in Egypt as a tool of repression. Since July 2013, the Office of Prosecutor and Court have been used as a tool of repression to target dissent, to silence dissent, to target human offenders, journalists, activists, individuals who are just exercising the right to freedom of expression and association. A sophisticated web of repressive laws have been introduced. Yesterday, Speaker mentioned or referred to some of these laws, including the anti-protest law, the anti-terrorism law, the law on terrorist entities, and other repressive laws. A web also of non-independent courts have been in charge of implementing these repressive laws. That include military courts, state of emergency courts, anti-terrorism circuits, misdemeanor courts dealing with issues related to publication of false information, a charge that I will specifically address in my intervention. As a result of this repressive framework, tens of thousands of individuals have been subjected to arbitrary judicial proceedings. Some of the most egregious examples of fair trial violations have involved trials involving hundreds of accused. Dozens or hundreds of whom have been sentenced to death or life imprisonment. The ICJ and its partners in Egypt has monitored many of the trials in Egypt over the past 9 years. We published extensively on the topic through a general report or through trial observation reports. My intervention will focus on violations of pre-trial rights and violations of rights at trial. At the pre-trial level, prosecutors initiated and judges continued prosecutions when the charges were unfounded. Under international law and standards, prosecutors have an obligation to dismiss case or discontinue prosecution when there is a clear lack of evidence to support the charges. In the specific case of Egypt, prosecutors went ahead with these cases even when the charges were unfounded. There are three trends in terms of the charges being used to target activists or dissent or those who are suspected of opposing the government. Publishing false information, belonging or joining a terrorist group, and undermining the credibility or the prestige of the state. In one of the cases that we monitored in 2021, the case of Ziad al-Alimi, 6 of the accused were charged with publishing false information. I would just give a concrete example of what the government considered to be a false information punishable by 4 to 5 years imprisonment. People accused writing in Facebook that the 30 July was a coup, that the accused alleged that there are prisoners in Egypt, that there are allegations of torture, that there are allegations of enforced disappearance. For the accused to write this information or publish it on Facebook or on Twitter was considered by the prosecutor to be publishing false information, and they were all convicted of it and sentenced between 4 years to 5 years imprisonment. Subjecting those arrested to enforced disappearances and incommunicado detention. Enforced disappearances state-sanctioned policy in Egypt. It includes cases of long-term enforced disappearances, and one of the cases that we've been monitoring as ICJ, the case of Mr. Al-Najjar, who has been subject to enforced disappearance for years. And there's also the case of people subject to enforced disappearances for few days or few weeks before appearing before the state's security prosecution office. In communicado detention, ICJ monitored documented cases in which the accused were denied access to counsel or to the external world for between 4 and 6 months. There is a presumption in favor of pre-trial detention applied by prosecutors and judges alike, and I think some of those who spoke yesterday all refer to how pre-trial detention in Egypt is a punishment in and of itself. I think what is problematic here is the framework itself. So it's not an exceptional measures applied based on the individual cases and the assessment of evidence in each of the individual cases. In practice, in the law and the practice in Egypt, pre-trial detention is imposed based on the gravity of the offense and the severity of the punishments provided for. So it can go up to 2 years. And even with this flawed framework that allows for pre-trial detention to go for up to 2 years, the government or the Egyptian authorities were not satisfied with this, and they tried to invent new tools to maintain individuals under pre-trial detention. Mahinur and others yesterday referred to the case of Tadwir. Tadwir is a practice that was developed by the Egyptian authorities to ensure that once a person finishes the 2 years of pre-trial detention, they will be accused or charged under new cases, similar events or similar cases, and in that way they continue to serve under pre-trial detention. And it's in addition to Tadwir, there is a new trend that is also taking place in Egypt, is that cases are duplicated. So instead of addressing all the charges against the accused in one trial, the government, the Egyptian government, the Egyptian authorities right now are adjudicating each charge separately. So in the specific case of Ala Abdel Fattah that many of the speakers referred to yesterday, he is charged with publishing false information with joining a terrorist group, has been convicted of publishing false information, and he continues while serving the sentence that he was convicted in relation to publishing false information. He continues also to serve simultaneously pre-trial detention in relation to the other charges that are still pending. In addition to this presumption in favor of pre-trial detention, but ICJ and other organizations, other partners documented there is a failure to respect the right to counsel and to ensure adequate time and facilities to prepare defense. In 2019 and 20, the ICJ was told by 19 lawyers that they are afraid themselves when they assess lawyers before the state security prosecution. Are concrete cases of lawyers who were arrested while they were carrying out their functions before the state security prosecution office. Mahinur Masri, who spoke yesterday, was arrested while leaving the state security prosecution office, and the case of Muhammad al-Bakr, a lawyer who was defending another activist, Ala Abdel Fattah, and who was accused by the prosecutor in the same case and charged, and who has been in prison since 2019, also facing charges related to publishing false information and joining a terrorist organization. There's a failure of prosecutors and judges to ensure access to defense to all relevant information and adequate time and facilities. A common trend also in Egypt is that lawyers don't have access to case files. There are sometimes cases that were people were convicted without even having access to the case file. Lawyers have to pay sometimes tens of thousands of pounds to get copies of the case files, and that's only before ordinary courts or civilian courts. Before military courts, access to case files is almost impossible. That's at the level of the pretrial rights. There are also violations that the ICJ and other organizations documented at the level of rights at trial. There is judges' application of laws that violate human rights and refusal of the judges to refer the cases to the constitutional courts. And the Egyptian law, judges have an obligation to assess the request of reviewing or challenging the constitutionality of the laws being applied. All these laws, repressive laws, as I mentioned in the beginning, were challenged by the defense lawyers, but the judges refused to refer them to the constitutional court. As a result, they continue to apply even when they are clearly in contradiction or in violation of both the Egyptian constitution and Egypt's obligations under international law. These judges' failure to ensure the harassment and intimidation of lawyers for the discharge of their duties. With our colleagues in Tahrir Institute Center, we have documented more than 34 cases of lawyers who have been subject not only to some arbitrary disciplinary proceedings, but also to criminal cases, being also accused of publishing false information or joining terrorist organization. In one specific case, the case of Babel, a lawyer was told that providing legal aid or legal assistance to someone who is accused of terrorism is akin to terrorism itself. And we had us targeting lawyers because they are doing their work and subjecting them to arbitrary disciplinary proceedings, arbitrary judicial proceedings, denying or severely restricting the ability of the accused to present evidence, call defense witnesses, or cross-examine prosecution witnesses. Most of these cases are based on reports by national security. The whole case is built on that reports by the national security, and there is no way for the lawyers to challenge that, or for the court to ensure that other witnesses that can challenge that evidence presented by the prosecution to be able to make the case for their clients. Convictions based on poorly reasoned judgments and without individual findings of guilt. I think this is something that we have monitored, we have documented in the cases in which there are mass trials and in which there are dozens or hundreds of the accused. Judges in their judgments or the reasoning, they would just include that they are all parts of joint criminal enterprise, and therefore there is no need to establish whether each one of those accused was responsible of the charges or responsible of the crime that they were accused of beyond reasonable doubt. They would just, convict them all on that basis. So those are some of the violations that's been documented by us, by the ICJ, and by other organizations. I think it's important here to highlight that when we are talking about fair trial, right, was this, I think Philippa mentioned that when it comes to fair trial rights in general, the first of these rights is the right to be tried by an independent, impartial court or tribunal established by law. The judiciary in Egypt is not independent. It hasn't been independent before 2013, but it's not independent specifically after 2013. The framework, the laws, the procedures governing the work of the judiciary when it comes to judicial appointment, judicial promotion, judicial accountability, when it comes to the role of the higher judicial council as a body in charge of ensuring judicial independence, there is a subordination to the executive, there is subordination to the political power. And as a result of this lack of guarantees for judicial independence in law and practice, we are witnessing a situation in which convictions are pronounced at an ministerial level without any respect of any of fair trial right, either at the pre-trial level or during trial. And that's practiced before all Egyptian courts when it comes to cases that are considered by opposing the government, whether they are opposing the government effectively or whether just suspected of opposing the government. That's it for me. Thanks.
Thank you, Saeed. The difficulty, of course, in the judiciary is that for many judges in situations like that, they sign their own arrest warrant by doing anything other than following what the executive wants, which is to quell any sort of opposition. I want to just take a moment and we are fortunate to have Professor Webb stay on with us for a little bit, but she has to leave. And I'd like to just circle back to one of the points that was made, I think, first by her and then again by Baroness Kennedy, which is this concept of derogation of the right to fair trial. We see that the legal documents specifically provide that there cannot be derogation, regardless of the circumstances, whether it be a pandemic, a war, a public emergency. But I wonder, there is apparently some legislation in Ukraine, which would allow Ukraine to try in absentia some of the Russian officials. And I would like to understand how, is this really some sort of derogation of the right to fair trial? Does this meet international standards? Professor Webb.
Thank you so much. And it was fascinating and disturbing to hear about the litany of fair trial violations just described by Saeed. So yes, a very good question on trials in absentia. The headline answer is that trials in absentia can comply with international human rights law, but only under very strict conditions. So the right to be present is in Article 14 of the ICCPR and many of the other instruments that have been adopted on the basis of the ICCPR. But it's not necessarily an absolute right. And actually many of the fair trial rights have some built-in flexibility that has to be strictly monitored. Now, one of those that is not flexible is judicial independence that we've heard about. That's not something that can be adapted. But we've already seen during the pandemic that one of the key adaptations has been the right to be present being realized through video link. So that has been found to satisfy fair trial conditions as long as the person is able to follow the proceedings, there's proper audio and technical support, and importantly, that they are able to realize their right to counsel through having secure communications with their counsel. It will not be in compliance with the fair trial if it's a video link and any communications with their counsel can be overheard or read by other people. But so that's one type of adaptation of the right to be present, moving on to a video or audio type of hearing. But what we're talking about in Ukraine is where there's very little prospect of having the defendant in custody because they are in Russia and they will not be entering onto Ukrainian territory. And of course, there is no prospect of extradition to Ukraine. And President Zelensky and his senior legal officials have decided, in order to have accountability for the massive atrocities that are taking place, to allow for trials in absentia. But these will have to be as I said, under very strict conditions in order to comply with international human rights law. First of all, the person charged has to be adequately notified of the charges against him. So that needs to be communicated. It can be done in a public way, a posting on a website. If there's a communication and address for him or her, that should also be used. So that adequate notification. Second, they have to either unequivocally waive their right to be present, and that would usually have to be expressly done in writing or in the face of the court. Otherwise, that person would be granted the right to a retrial if and when they became present and able to participate. So it's either an unequivocal waiver, very strictly regulated, or the opportunity for a retrial in person. And finally, the defendant's or the person charged's other fair trial rights, especially the right to counsel, must be respected during a trial in absentia. So there should be a counsel representing them. There should be best efforts for that counsel to be in communication with the person who is absent in order to present their case and to be able to communicate securely with them. So very narrow conditions, but it is possible. And I know that Ukraine is seeking advice on how to ensure its human rights obligations are upheld. Ukraine is a party to the ICCPR. Ukraine is a party to the European Convention on Human Rights, both of which have a lot of case law and jurisprudence that set out how a trial in absentia can still be a fair trial.
I've had several conversations with members of the Ukrainian National Bar Association, and they are very committed to making sure that in all of this, their conduct is beyond reproach in terms of law. So I hope that they can meet the standards to which they aspire. I think it's just a very difficult situation given the situation and the personalities of the two countries. So thank you very much for that response, and please stay on as long as you can to join us. Now I'd like to turn the mic over to Giuseppe Anconcio, who will address a little bit different aspect to this in the international world, which is the international implications of the ongoing repression that exists in Egypt and the sociological effects of the current crackdown on different groups of activists. Giuseppe.
Thank you for having me here today. I've been covering the events in Cairo before, during, and after the 2011 uprisings. I was shortly arrested on February 2nd, 2011, while covering the events in Tahrir Square. And today I would like to tackle civil society mobilization and demobilization in Egypt, in reference with international implications. Let's start from what happened more than 10 years ago, announced in 2022, so it's 11 years ago. There were great expectations. There was the youth in the square, in Tahrir Square. There were a lot of women participating in protests. There were many workers, many LGBTQ activists. There were graffiti makers, migrants. There were Islamists, of course. They were asking for Aish Orreya wa Dalat Mahia, it is bread, freedom, and social justice. There were alternative networks, so poor people, street politics. There was a lot of cyber activism, a lot of people taking part in protests, even popular committees within poor neighborhood in Cairo and other major cities in Egypt. Afterwards, the society in Egypt has been strongly, highly polarized. And this brought the victory of the Muslim Brotherhood. It was in power for 1 year between 2012 and 2013. We can ask here if really the Muslim Brotherhood governed when it was in power. How did they act towards the youth of the square of Tahrir Square? Many of the young people have been left to the streets while the Brotherhood was in power. And even they deceived their own constituency. So this brought to the 2013 military coup.
And yesterday and today we've been discussing a lot about this. There was this slogan that was quite familiar to us in 2013. It was the army and the police, one hand, الجيش والشرطة إيد واحدة. So there was this alliance between the army and the police that gave the power to Abdel Fattah al-Sisi to succeed in his idea of having a military coup. He already used the virginity test during the protests, so preventing the participation of many women in Tahrir Square protests and other protests after 2011. And now we are in a current condition of repression that has been mentioned by the other speakers, especially by Maria Noor El-Masri. There have been this strong control of a state institution coming from the army. This is a kind of heritage coming from colonial media, from colonial time. And this targeting of all kinds of activists. They've all been labeled as terrorists. There are several cases that have been mentioned. I would like to quote one of them that I didn't hear yet. It is the one facing by Monima Bolfotou, that was leader of a party that called Strong Egypt, and many others supporting the Islamists that are in prison, even we don't know their names. Or even the case of the former president Mohammed Morsi, who died in detention. And we cannot hear the use that has been done of the terrorism in Sinai to allow emergency laws that have been in place until a few months ago. And the Rabaa massacre has been mentioned by some speakers. The Rabaa massacre where hundreds of people died one day, 2 days after there were confrontation in Naqda Square and Rabaa because of the participation of the way in which the Islamists were supporting the legitimacy of their president, Mohammed Morsi. So the question today is, how did the international community react to all of this? On one hand, we can talk about the US, so the United States and Egypt, and the relationship between the two countries, the ties between these two countries. All of us has in mind this speech of Barack Obama, the US president, when he went to the University of Cairo. He was talking about democracy, saying we want democracy in Egypt. Every kind of outcome of a free election will be accepted by the United States. And actually this happened because the outcome of the election was the victory of the Muslim Brotherhood. What happened afterward? That after the military coup, the US didn't do anything to support the Muslim Brotherhood elected president and left basically the country in a condition of military regime. It is the now ongoing situation in Egypt. With the Trump administration, let's say that al-Sisi became the favorite dictator of the US president, and he actually said this expression. So basically there were strong ties between the US and Egypt. What happened afterward? There was a strong expectation with the Biden administration, but actually the opening with the Biden administration have been very light. So still there are thousands of political prisoners, and the pressure coming from the US is very light. $1.3 billion of US aid to Egypt are still there. Even if they've been slightly cut, they are still there. And let's have a look towards the EU. How do you react to the repression in Egypt? Well, there were no strong reaction at all. Let's think about Italy. Some of the speakers yesterday mentioned Italy and the ties between Egypt and Italy. There are several strategic points that make these ties very strong and relevant. One of them is the ZOR-9 platform. It is a gas platform that is based in the Eastern Mediterranean region. Another one are migrants. Italy is strongly committed to support Egypt because Egypt is supporting Khalifa Haftar in Libya. He is the leader of Cyrenaica. This is quite strategic for the Italian interest. And the other point is the increased connection between Italian military industry and the Egyptian army that is bringing more and more weapons to Egypt. But let's look to France. François Hollande has been one of the first presidents of EU states going to Egypt, so recognizing the authority of al-Sisi, participating in the celebration for the extension of the Suez Canal. And actually, there are several reports tackling the issues that French weapons have been used to attack protesters in Egypt. So the ties between Egypt and France are even stronger than one between Italy and Egypt. And we can have a look towards China and towards Russia. How much Putin and Abdel Fattah al-Sisi, even between Egypt and China. Sisi went to the Olympic Games this year there is this project of One Belt, One Road, and quite Egypt is part of it. So China is extending the economic presence in Africa, and Egypt is one of key figures for China interest in Africa. And even we don't know what will happen now with the wet crisis and the war in Ukraine that can bring a lot of problems to the Egyptian economy that still has several issues to be tackled. The point is that the Egyptian authority tried to have money coming from the IMF. $12 billion arrived in the last few years, more 5 during the pandemic. There have been money coming from the Emirates, from Saudi Arabia, $12 billion again. Let's say that to have this money, especially the one from the International Monetary Funds, means that the Egyptian authority had to cut subsidies for the poorest. They had to cut subsidies for bread. They had to ensure austerity measures that quite were relevant for the Egyptian people that are struggling every day in condition of poverty. So to go back to the main point that we tackled at the beginning of this intervention, the situation of the civil society after all of this, after all this support coming from the international community towards the Egyptian authority, we can say that the Egyptian activists are living in a condition of despair, of disillusionment. Some of the speakers mentioned Alaa Abdel Fattah, and all our support should go to him. He is in hunger strike now for many days. And his condition and the condition of all political prisoners worsened during the pandemic. We can actually mention 3 groups of activists that have been strongly tackled, they strongly face the repression ongoing in Egypt. One of these groups are the LGBTQ activists, and I want to mention today one of them, that is Sarah Ghazi. She was in prison in Egypt, she has been released, she went to Canada, and she committed suicide. And she was in prison just because she was raising a rainbow flag during a concert of a Lebanese band called Mashru Leila. So actually for no reason. And really you can understand that feeling of despair when she committed suicide. Another group of activists that really was every day looking to their participation within the demonstrations in 2011 and afterwards are the workers, those ones supporting independent trade unions. And one of them, of course, is Haitham Mohammadin. It is one advocate for workers' rights in Egypt. And still, all of them are facing strong repression. There has been a ban on the law permitting independent trade union in Egypt in these last few years. So actually, it's very problematic to demonstrate, to make strikes, especially because the Egyptian army has a strong control within factories in many Egyptian cities. And the third group of activists that I want to mention today are researchers. One of them has been mentioned, Ismail Iskandarani, that was researching on Sinai and is in prison, and basically we don't know when he will be released, if he will be released. And the other one is Ahmed Samir Santawi. We hope that his case will be followed with a good outcome. To conclude, I want to that you bring home the fact that mainstream media were discussing about the Arab Springs. Many of them were discussing about the rise of ISIS, of terrorist groups, of Islamist groups. But here we have civil societies in many of the countries where they've been protesting, where people have been protesting. However, the outcome has been different. Now Egypt is not a country for journalists, Egypt is not a country for researchers, it's not a country for human rights defenders, and it's problematic because the international community supported autocracies and military regimes only for strategic reasons in all the MENA region, including Egypt. And this is quite the opposite that we were expecting, because we had high expectation when people were protesting in Tahrir Square. Thank you very much.
Thank you, Giuseppe. I think Baroness Kennedy has her hand raised. Baroness Kennedy?
Yes. I really want I'm hoping the echo will go. I really wanted to raise the issue of the independence of lawyers. and the role that bar associations must play in that. Our experience, though, at the International Bar Association is that often when it comes to authoritarianism and a government that is in some ways interfering with fair trial, is that lawyers and bar associations don't come to the defense of lawyers because they too fear for their existence. They too are suffer the chilling effect of living in a society which is somewhat authoritarian. They know there will be consequences if they take a position that is too firm on protecting lawyers who are doing their job of acting for people who are unpopular. Now, I raise this in the context of Ukraine. One of the problems is that we know that fair trial means that there has to be access to independent counsel who will, without fear or favor, defend those on trial. And so, for example, when it comes to Russian personnel, military personnel, or the leadership in their absence who might be put on trial, it is absolutely vital that there is good representation by lawyers from the Ukrainian bar. And I mean, the Russians may try to introduce their own lawyers into the system, but I think they would have to be called to the Ukrainian bar for that to happen. And that should be facilitated if at all possible. It's really important that lawyers are prepared to come forward. Unfortunately, in a situation of conflict or in a situation where there is an authoritarian regime or in many different situations, lawyers are unwilling to take these briefs on behalf of people with whom they will be associated. They will be seen as being disloyal to their own state. And there needs to be a job of work done by bar associations to explain that lawyers have a role in protecting a system, a fair system, and therefore people must be properly represented. And already lawyers in Ukraine who acted for the two Russians who so far have been tried and convicted of war crimes, the lawyers who have acted have been excoriated, and many of the people in the public say, "How could you do such a thing?" And they are having to live in that difficult climate. So it's important that bar associations are prevailed upon to be supportive and to encourage lawyers to step forward. And indeed, they should take the role of appointing lawyers to do these cases. And a lawyer should feel the duty to actually respond. So that it's actually, even if it's the president who asks that people step forward and do these cases, then there's a protection for the lawyers. I myself have, in Britain, acted for people accused of terrorism during the Irish Troubles. And I often was accused of being in some way complicit with my clients, or that I was in some way failing to be on the right side of the British state, and had to always make the point that acting in these cases is a protection for all of us because we're preserving the rule of law and we're preserving fair trial. So I really want us to emphasize the importance of independent lawyers protected by their bar associations and protected by the political class. And so I really do feel the leadership in Ukraine should be very explicit in saying this is what has to be done. And that way Ukraine can maintain the moral high ground. That was what I wanted to say.
Which is really, we've heard all of the problems, we see the issues. What is it that we can do, either as lawyers, as judges, bar associations? I think your point is an excellent one, that bar associations have a very strong role in protecting the independence of lawyers. I think one thing that we all need to keep in mind as lawyers, as judges, as media, as researchers, everyone, we need to convey this to the civil society. We need to convey the importance of the independence of judiciary and lawyers, because it is not really just for us. It is to protect citizens' rights. And I think, I know there's a group in Poland called Free Courts Initiative, and that is one of their major goals is to put out this information in ways that the average person understands. So I think they're doing a great job, but I think all of us need to do more of that. I'd like to ask Saeed, what do you think can be done to ensure judicial accountability when prosecutors and judges really are at the forefront of the crackdown on persons in Egypt who have been arrested?
Definitely, I think the question of judicial accountability is an important one, and it's important because it has also been used by authoritarian government to undermine judicial independence. What's happening in Tunisia right now with the president dismissing judges without any process, just through decree, it highlights this tension between judicial accountability and judicial independence. How you ensure judicial accountability, I think it's important in specific context of Egypt to highlight that the judiciary as a whole is not independent. Ideally, when judges and prosecutors are abusing their powers, are not complying with well-established procedures, are not acting in defense of human rights and the rule of law, but rather as a tool to oppress and to target the executive opponent. I think in such case, it has to be like judicial accountability can be done through the judiciary, if the judiciary is independent, through disciplinary proceedings, through compliance with well-established code of ethics and judicial conduct, with all the guarantees necessary for those judges to be held to account, and for those judges to be reminded of their legal obligations and their professional obligations to act in defense of the rule of law and in compliance with the law. When the law itself is problematic, I think for judges, there is always the question, shall I comply with it even if I know that this law, for example, the anti-protest law, that denies the exercise of basic rights. You can recuse yourself from cases, and I think this is not something that we witnessed in Egypt. You can refer those problematic laws to constitutional court to rule on their constitutionality. This is not something that we witnessed in Egypt. To the contrary, judges are refusing to refer these laws. And you can, I think, in terms of just, even if you are receiving orders, you can refuse those who would prefer to resign and to not be part of such judiciary than to accept. And I think it's important not in the context of Egypt right now, there are judges in Tunisia who are willing to resign and to not be used by the executive branch. It's a lot to ask, I know, and I know that judges at the end of the day, they are human beings, they have mortgages, they have their lives, they have their kids in school, but it's important to highlight that judges or the judiciary is the last line. It's important to highlight, if in Egypt there is one day a process of transitional justice or a process of dealing with the legacy of the serious crimes being committed in the country, it's important to assess and address the complicity of prosecutors and judges in cases of serious human rights violations. We have documented, and it's not only us, by UN bodies, by other organizations, that cases in which death penalties were pronounced were given after unfair trial, grossly unfair trials. In cases in which the accused would go to court and tell the judges that they were tortured to give confessions that they didn't commit any crimes, and they would tell the judges that they were electrocuted, they were subject to all kinds of torture, and the judge would just dismiss this testimony from the accused and would just rule on the basis of the security service report and convict people to death sentences, and the death sentence is carried out. I think we are here at the level of complicity in crimes of arbitrary deprivation of life, and I hope that one day, if Egypt is to establish a transitional justice process, and if there is a prospect of accountability inside Egypt, that these cases are being dealt with and addressed adequately. And finally, I think in terms of the responsibility of the international community, I think what's been said about all the checks on the president's power in Egypt has been dismantled. No independent media, no independent civil society. Lawyers are being prosecuted and put in jail, and judges and prosecutors are used as tool of oppression. So what avenues are there to ensure accountability for the crimes? And the crimes being committed in Egypt, when it comes to enforced disappearance, when it comes to arbitrary deprivation of life, when it comes to torture and ill treatment, those are serious crimes under international law and crimes of universal jurisdiction. So states have also an obligation to look at these crimes, investigate them, and prosecute them when necessary. Human rights organizations to establish a monitoring mechanism to respond to the urgency and the gravity of the situation of human rights in Egypt. And that request should be supported by individual states, and that such mechanism should be established to respond to this situation.
Thank you, Saeed. Giuseppe, the question for you. In terms of international accountability, what are some of the ways that the international community can have some effect? I know there are transnational solidarity campaigns. Do these work? Do they do anything that is positive for civil society, for holding Egypt accountable for its violations?
This is a very important point. I really think that transnational solidarity is the most important tool that we have in order to support the Egyptian civil society. Let's think to several examples. The campaign of the Bologna University for asking for the freedom of the issue of Patrick Zaki. This has been a strong campaign, a solidarity campaign that brought about the reasons why human rights are not tackled in Egypt. Supporting, for example, the mothers of political prisoners is another point. Or even petitions that came from the EU Parliament for several MPs or the US MPs. Events like these, or international human rights associations or think tank that support human rights, like Scholars at Risk and others, that do campaigns supporting human rights in Egypt, or even ordinary citizens that mobilize, supporting Al Abdel Fattah is under strike, or to a certain extent, in more general terms, we can say that we have to be reminded that there is a need for change coming from the Egyptian youth. And one day or another, this need for change will come out. There might be new social movements, there might be new kind of mobilizations, but actually this will happen. On the other hand, at the international level, we mentioned several countries, but we know that the issues are going on another level, because there are several gas interests, stronger support coming to Egypt because of the war between Russia and Ukraine. And the other point is that wet coming 85% from Russia and Ukraine is very important, very relevant for the Egyptian economy. So really it's very problematic, but we have to continue with our transnational solidarity towards the Egyptian civil society.
Thank you, Giuseppe. It does seem that we need, all of us in this room need to put pressure on our own governments to hold Egypt accountable if we're going to give money, we need to get change from Egypt in terms of human rights. I know the United States is beginning to do some of that. I know other countries are the EU is trying to do that, but I think we need to try to encourage our governments to do more of that. I think it's essential. I think we are at the end of our time, so I'm just going to see if any of our panelists have anything, a 1 or 2 minute wrap up, any takeaways that they would like to leave our listeners with. Baroness Kennedy.
Sorry, let me come back in. Sorry, I'm trying to put my camera on, yes. Well,
Okay.
this has been a really important session, and I want to thank Saeed and Giuseppe and Philippa for their important contributions. The world is in a parlous state at the moment because the rule of law is being eroded, even in Western democracies. And we're seeing it here in the United Kingdom as well, a dismissal of international conventions which our government has signed up to around the protections for asylum seekers, around the whole issue of genocide and being unwilling to call to book and to prevent genocides that are taking place by trade embargoes, or at least using trading as a way of negotiating for some of the changes. And so and we're also seeing it with regard to internal protections for human rights, with now a way of seeking to step back from the Human Rights Act, which has been part of our legacy after the Second World War and our commitment to international human rights. So we're seeing a step away from the international. The rise of nationalisms has unfortunately that sort of wonderful tapestry of rights created, particularly after the Second World War, is being eroded because of the rise of nationalisms and ethnic nationalisms and authoritarian nationalisms. And so there is a problem for us about reasserting the importance of the rule of law and how fundamental it is to a democracy. And we have to be having our governments, those of us who are living in Western democracies, make that clear in all of their interactions with governments elsewhere. But you can see for yourselves that even now, the European Union, which has great economic levers, is unable to do it with, for example, with Hungary, which has been in breach of many of the values that were supposed to be part of being in the European Union around the protection of rights. And so I really think that we've got a job on our hands, and it really is important to reassert the fact that these are issues that cross borders. These are issues where I would like to see universal jurisdiction, as just been mentioned, used more actively by nations who have signed up to international protections, and we should be actually using targeted sanctions against those who are abusing human rights, and calling upon our governments to do that. It's the sort of Magnitsky framework. So I've been privileged to listen to the others on the panel, and I want to thank you for including me in this. And the International Bar Association's Human Rights Institute is here at your disposal whenever we can help and put out statements around what is happening in different countries.
The past 2 days, they are fighting the fight by themselves. They are fighting the fight without any domestic support and without any protection from the national institutions that should be acting in defense of their rights. It's important for us individually, for bar associations, for lawyers, for human rights defenders, for civil society organizations, media, international community in general, to help and amplify their voices. And I think it's also important for individual states to act individually and collectively to ensure that accountability is ensured for the crimes and abuses being committed in Egypt, either through mechanisms in the Human Rights Council, or when it comes to crimes under international law through the use of universal jurisdiction.
Well said, well said. Giuseppe.
Yes, I would like that you take home the relevance of the Egyptian civil society and how the Egyptian civil society is diverse, is interesting, is relevant to us. It's wonderful to study it and to see how it developed in the last few years. The needs for social rights, human rights, women's rights, LGBTQ rights in Egypt. The need for accountability of the Egyptian elite, of the Egyptian army, of the Egyptian politicians, that is quite relevant for the development of the country, and the necessity of the international community to put pressure for the respect of human and social rights in Egypt that is needed nowadays, and it's very important that this comes from Italy, but from all over Europe, from the US, and from all over the world, not only from the governments, but from civil societies and from solidarity transnational campaigns. Thank you very much.
I want to thank our panelists for doing an excellent job, and I just want to remind everyone that Egypt is a cautionary tale, as is Turkey, as are many other nations. This can happen in my own country. There are many worrisome things which are sliding us along the line. I hope we are far from that line, but it can happen, and we need to be ever vigilant to ensure that it doesn't. So we have to make a lot of noise. Thank you very much.
Well, I'm very happy to be here, and I would like to express my thanks and those of the Paris Bar to Palermo Bar Association, which welcomed us in a very beautiful location and organized a very beautiful international fair day trial. And just know that Julie Couturier and Vincent Mioret, who are the chair and vice chair of the Paris Bar, and asked me to send you their greetings and their friendship. As a member of the Commission of the Human Rights of the Paris Bar, as the Secretary General of the International Observatory of the Indentured Lawyers, I can, of course, only be happy and sensitive to the honor of being here with you, because I know that you are all extremely attached to this principle of fair trial, without which there is no democracy at all and no independence of the judges and the lawyers. In a few minutes, we will present the Ebru Timtik Prize. And as all of you, I can see the face of Ebru Timtik on this poster behind. And I think that for all of us, it's courage, and this face has become a symbol of the commitment of the defense, of courage, and of attachment to the principle of fair trial. In Paris, for example, but I think it's the same in many places all around the world, we have displayed huge pictures of Ebru Timtik and Eita Kunchal and Nassim Sotoudeh, because their faces remind us every day of the importance of the rule of law and the risk faced by human rights defenders in countries where the rule of law, the independence of lawyers and judges, and the principle of fair trial is constantly violated. Sorry. So each time I can participate to an observation with the other observers in Turkey or somewhere else, I can just realize how amazing these lawyers are, and how much they need our help and support, and how much we need to always remember in this situation where we are observing trials and trying to help defenders, we always have to remember the face of Ebru Timtik. And speaking about the indentured lawyers, I'd like to present you the shelter program at Paris Bar, which we decided to set up an hospitality and shelter programs for lawyers under threat throughout the world. I'd like to speak about that because I think it's quite related to the fair trial principle. So what we call the shelter program REPI is an initiative which seeks to give lawyers the opportunity to spend some time away from their respective countries and escape the stressful and difficult situations they operate in, and to keep those most at risk away from any immediate danger. So with the shelter program REPI, the lawyers may therefore find some respite and experience the stress-free environment provided by the French capital while developing their professional networks and skills throughout their stay. So the first beneficiaries of the shelter program REPI were welcomed in 2021, and the feedback is quite positive. It's a short-term program, as we believe that it is more dedicated to the professional life of our colleagues, and its aim is not to encourage our colleagues to go into exile, but provide them into a breathing space in their difficult personal and professional lives. With the program REPI, the lawyers hosted will be hosted for a fixed period of between 2 weeks and 3 months, and the program will cover all costs and make the necessary arrangements for the lawyer's stay from departure to returning home. I mean, travel, accommodation, living, and so on. And of course, this scheme, as I told you, is open to lawyers to any country. And the 3 requirements for protection in Paris are the following. The lawyer is threatened by governmental or non-governmental actors because of its of his or her activities. The lawyer is still active in his or her country or has only recently left the country danger, and beneficiaries will be chosen based on the three different criteria, including how high and imminent the risks are. There's a secure application, and of course, all this is secret, so that we can we don't want to put these lawyers in danger. And the aim of this program is not to welcome a very large number of beneficiaries, but to welcome them in the best possible way within the framework of the state, especially adapted to their needs and wishes. When they are in Paris, they can benefit from a workplace separate from where they are staying, allowing them to keep abreast of the cases, and they can take part in the program. They can also receive training and access various legal libraries and databases. And we can arrange meetings with organizations, media, and so on. And of course, the medical and psychological support is offered with the Primo Levi Psychological Care and Support Center. So, for example, the last beneficiary of this program in Paris was a lawyer who has spent 10 years in military prison in the Democratic Republic of Congo. He was sentenced to death and later pardoned. And after 10 years of detention, it was essential for this lawyer to have a complete medical checkup during his stay in Paris, and that's what we provided him during his stay. So that's the reason. We all know that the number of lawyers around the world is in danger, is constantly growing. And we all know that we have to maintain the possibility of a defense by offering this kind of rest. So that's why the repeat program was created by the Paris Bar. And we will be really pleased to give you more details if you're interested, because we really think that if the other bars help us, we can maybe achieve to give some rest and some security to lawyers and dangers around the world together. And because we are speaking about Indonesian lawyers, because we are speaking about Ebru Timtik, this is where, after presenting that program, I need to say a few sentences concerning Ebru, because you are going to hear her voice in two videos. First one, it's Ebru Timtik's original voice. And she will see that she explains why she's in hunger strike. And her voice was recorded in very difficult conditions, but you will hear how determined she was. And there's also another video. It's Ebru Timtik original voices. So let's have a look to this video and remember the courage and the energy and the determination of such a woman and such a lawyer.
dostlarımızın yüreği yakar. Adaletin açığını çekenleri harekete geçirir. Bizim güvendiğimiz, siz
So after such a video and after hearing Ebru Timtik voice, it's time to speak about the Ebru Timtik Award in remembrance of such a lawyer. And to give this award, we have a selection committee, and I'm going to present the members of the selection committee. First, I would like to speak about Aida Saif El Wala. As you can see in the program, Aida Saif El Wala was born became in 1954, and she became a political activist herself while at university. And she is a psychiatrist, and besides combating torture and human rights abuses, Aida has continuously expressed her political opinion more openly, denouncing Egypt's police and challenging former President Mubarak and his regime. And as a member of the Organization for Defense of Egypt protesters, she documented the abuses committed by police and army during and after the 18-day revolution. We also welcome Gerhard Eisner, born in 1954 in Vienna, Austria. He's a doctor juris who studied law and sociology at the Universities of Vienna and Munich. As a judge, he's a former president of European Association of Judges, president of International Association of Judges between 2012 and 2014. He has taken part in numerous expert missions, training programs, and roundtables organized by the Council of Europe. And he acted as an expert in the Venice Commission's mission regarding opinions on specific legislations in Armenia and Ukraine. We also welcome Professor Monica Rocco. She's a full professor of Arabic language and literature at the Asia, Africa, and Mediterranean Department of the Oriental University of Naples. She acted as the president of the European Association for the Modern Arabic Literature and of the Italian Society of Middle East Studies. And she published numerous articles, essays, and books reflecting to a field of interest. And also Susan Adely. She's a labor and community organizer and human rights attorney who has worked in New York, Chicago, Egypt, India, and other locations on the spectrum of labor and human rights initiatives. And she's the co-chair of the International Labor Justice Working Group, International Committee of the National Lawyers Guild, bureau member of the International Association of Democratic Lawyers, and a long-time Arab-American community organizer. And finally, as the last member of the selection committee, I'd like to speak about Senem Finkanci, who was a former president of the Human Rights Foundation, which is Turkey's largest human rights organization, and currently chair of the Turkish Medical Association. And as a doctor, Dr. Finkanci has received numerous awards, including the Asian Peace Prize in 2018 and the Arendt Link Award in 2014. She received her associate professorship at Istanbul University in 1990, a professorship in 1996, and was promoted to the head of the department in 1997. In 1999, she established the first forensic medical outpatient clinic in Turkey. This Dr. Finkansi has also studied classical archaeology at Istanbul University. I have to mention that they all also cooperated with Ebru Timtik, who, as you know, is also an imprisoned lawyer in Turkey and who is a sister of Ebru Timtik. So I give the micro to Monica and Robert.
Thank you so much. I am really honored and touched to announce you that the 2022 Ebru Timtik Award has been granted to imprisoned Egyptian lawyers and human rights defenders, Muhammad al-Baqir and Haytham Mohammadin. The 2022 Ebru Timtik Award jury considered 4 nominations that were presented to them. 3 of the 4 nominations were lawyers, all of whom are imprisoned in Egypt. One of the nominations was an organization working on the rights of refugees and asylum seekers. The committee deliberated during 2 online meetings and was faced with the difficult task of choosing among the 4 honorable candidates, all of whom either have been subjected to grave human rights violations or who are working against those violations or both. The deliberations were enriched by the opinion of Ebru Timtik, sister of Ebru Timtik, who died in prison after a long hunger strike. Ebru, who herself is being held in a high security prison in Turkey, have been sentenced to 18 years and 9 months, corresponded with the committee via letters. The final decision of the jury was to award these years award to 2 individuals, both lawyers and human rights defenders, who, in the eye of the committee, were equally engaged in fighting for human rights. Without taking their own risks into consideration, they intervened in many cases to safeguard human rights, including fighting for the right to a fair trial for their clients and others. Both the chosen candidates were victims of unfair legal procedures, and both of them are currently imprisoned as a result of their work. The committee saw no possibility to weigh differently the violent engagement for justice, freedom, and fair trial to each of these men, including the fact that both of them have been victims of unfair trials. The 2022 Ebru Timtik Award, therefore, was awarded jointly to both individuals, lawyer and human rights defender, Muhammad al-Baqir, currently serving a 4-year prison sentence in the Torah High Security Prison 2 in Cairo, and lawyer, human rights and workers defender, Haytham Mohammadin, who has been in and out of prison several times since 2011. Muhammad al-Baqir, founder and leader of the Adala Center for Rights and Freedoms, has a long and renowned history in defending individuals whose rights have been violated and of providing pro bono legal support, including to those detained for exercising their rights to assembly and expression. Civilians tried before military courts and members of marginalized communities, among them religious and ethnic minorities. He has been sentenced to 4 years by a state security court whose decisions cannot be appealed. The sentence came after spending almost 2 years in pre-trial detention, after he was arrested in the office of the state security prosecution, where he was attending as the lawyer for a prisoner of conscience, Ala Abdel Fattah, blogger and writer, who also currently is in prison and on a hunger strike. Upon his transfer to prison, al-Baqir was subjected to beatings, forced shaving, and abuse by prison officers. During his trial, neither al-Bakr nor his lawyers had access to the case file. He was not granted private time to deliberate with his lawyers, and the sentence was ratified by the president shortly thereafter. His 4 years in prison will start on the date of the sentence, not counting the previous 2 years he had already spent in prison. He currently is being held in the Torah High Security Prison too. Haitham Mohammadin is a human rights lawyer and trade union activist who has worked in several human rights organizations and has engaged in several activities, helping workers organize their independent unions. Mohammadin was arrested in June 2019 at a police station while he was meeting with a client there. He was sentenced by the court as a condition of his release from a previous arrest. He disappeared for 3 days, after which he appeared in front of the state security prosecution and was accused of the usual pretextual charges, including alleged terrorist activities and spreading false news. In 2021, he was acquitted by a court decision, but the following day, he was faced with a new case with the same charge, beginning a new cycle of pretrial detention. He is currently being held in Qanater prison for men. Mohammadin has not yet been brought to trial despite his prolonged detention, reflecting Egypt's pattern of abuse of the rule of law that is common in Egypt. Similarly, the lack of a fair trial to which al-Bakr was subjected is also a common state of affairs in Egypt, as Egypt systemically and systematically denies due process and fair trial to most defendants. Both laureates have shown great dedication, determination, and courage in their work as lawyers and human rights defenders. Through their work, they tried to uphold the rule of law in increasingly difficult circumstances in Egypt. In conclusion, by honoring people's lawyers and human rights defenders, Haitham Mohammadin and Muhammad al-Bakr, we are also honoring the tens of thousands of political prisoners in Egypt, all of whom either continue to suffer prolonged and harsh detentions. Moreover, if they are allowed to appear in court, the lack of basic fair trial standards results in harsh and severe prison sentences for most, including many committed lawyers and human rights defenders who remain behind bars. Granting the award to al-Bakr and Mohammadi will focus worldwide attention on their plight and on the plights of innumerable others who remain imprisoned because they sought to defend fair trials or human rights of others. Thank you. I would like just to say some sentences about a person whose name has recorded during these 2 days. It's 8 days now, and he's now also a UK British citizen, but the Egyptian authorities do not allow the British authorities in Cairo to meet him. So there is an international campaign of a symbolic one-day hunger strike that I invite you to join or to share with other people. So thank you.
Thank you, and to remind us that the International Theatrical Day has always aimed to combine art and human rights. And as Sharon told me, last year we had an amazing art piece as an award, and this year again, because of this tradition of combining art and human rights. We have a unique piece with an impressive story as a award. So let me introduce you to the creator of this work, who is Fatma. Maybe I can say a few words on Fatma. As you could see in the program, that she was in London and Istanbul, and she studied philosophy and history of art, and she had a lot of exhibitions around the world. She's an artist, and I speak about this award.
Hello.
Hello.
Hello. Connecting for this great panel. So hello everyone. I'm Fatma Bucak, an artist from Turkey. And firstly, I would like to say I'm honored and humbled to be part of this panel and the Ebru Timtik Award that focuses on such an urgent and important subject, that is rapid deterioration seen in human rights. So thank you very much, Ayşe Bingöl, especially for involving me in such as this one with an amazing jury. And I'm humbled to know that a small work of mine can be seen, hopefully, by these two very important Egyptian lawyers and human rights defenders that are granted the Ebru Timtik Award, Mohammed Al-Bakir and Haytham Mohammedin. I would like to say just a few words about myself and say a few words about the work also. So I was born in Turkey to a Kurdish family and raised in Istanbul. Raised in Turkish in a Kurdish-speaking household has its contradiction and uncertainties, as is the case for majority Kurds living in big cities. I left the country in the early 2000s and actually never left it at the same time, since I carried it through my works, in most of my works. As an artist, I found myself often addressing politics, identity in my works that they are in different mediums, subjects that they are continually absurd in conflict and rebellion. And the geography I come from undeniably is one of the main reasons for which these questions are prominent in my works. A country where every day we get up with a piece of news about many being subjected to arbitrary investigations, trial, arrests, detentions. And it is unbearable to watch the loss of fundamental human rights and freedoms in silence. So for this, being part of this big event with a small work such as Black Ink is very, very important and makes me basically shake in this moment. I would like to say a few words about Black Ink. Black Ink, it's a print. It's a work of testimony. It's a memory that doesn't want to disappear. It's a document of a recipe for an ink used to print its letters. So the recipe states the tragic event of its own origin. Ashes from a burned Kurdish book and raised house were added to a solution to create this black ink. Kurdish language has been long persecuted in Turkey. Black ink bears the witness of one of the events to a burning Kurdish publishing house in Diyarbakir, a city in southern Turkey. Allah's fires have been deliberately incited through the history to destroy the cultural heritage and memory in many other countries. So the center of the Black Ink is trying to make sure that that narrative is not going to be lost and being carried, being part of maybe the household of those two very important people that they are awarded here today, it makes me very, very happy. So I would like to stop here and thank you all for letting me part of this very important panel. And thank you very much.
And today with us, we also have a young colleague from Turkey, Siren Yilmaz, who was able to work together with Ebru Timtik, were there when she was fighting for territorial rights, and Siren will present the awards. She only speaks Turkish, so maybe you need to register on the Zoom link.
Good afternoon. I'm sorry, but I'm speaking Turkish. Merhaba. Öncelikle sizleri, burada bulunan tüm meslektaşlarımızı ve online olarak dinleyen tüm meslektaşlarımızı, hukuk örgütlerini ve hak savunucularını selamlıyorum. Sizleri Ebru'nun sevgisiyle selamlıyorum. Çünkü Ebru herkesi şaşırtacak kadar dünya halklarına sevgiyle doluydu. Zannediyorum en çok dikkat çeken yönlerinden birisi buydu. Türkiye'nin her karışını, toprağın her karışını gezmiş, hukuksuzluklara, adaletsizliklere karşı mücadele etmişti. Ve elbette o çok sevdiği halkına karşı bunu yapanlara, eziyet edenlere, işkence edenlere, bu adaletsizlikleri yapanlara karşı da çok büyük bir öfke doluydu. Ve bu sevgi ve tam da bu sevgiden doğan öfke onu büromuza, kendisine ve halka yapılan adaletsizliklere karşı bedenini ölüm orucuna yatırmayı, bedenini açlığa yatırmayı, ölüme yatırmayı tercih etti bu sebeple. Ama Ebru'yu size en iyi kendi sözleriyle anlatabilirim, kendi mütevazı sözleriyle anlatabilirim. O yüzden size onun bir mektubunda yazdığı sözlerini okumak istiyorum. Ben tarihe en azından kendi küçük yaşamımızda adımın tertemiz geçmesini isterim. Umuyorum ki öyle olur. Boyun eğdi, bak zor görünce kaçtı şeklinde geçmesini istemem. O açıdan bizim tarihe karşı da, halka karşı da verilmeyecek bir hesabımız yok. Ne bugün olduğu gibi tutsak ederek mahkeme karşısında ömrümüzle tehdit edildiğimiz zaman, ne de kişisel bir menfaat ya da parlak bir gelecek vaat edildiği zaman bizim cevabımız değişmeyecektir. Tarih boyunca da böyle olmuştur. Borç defterlerimiz, olmayan banka hesaplarımız buna kanıt. Biz Marksist-Leninistiz, biz devrimciyiz, biz sosyalistiz. Öyle büyük anlı isimlere gerek yok. Tarihte bir ak sayfaya sığar ömrümüz demişti Ebru ve kendisini işte bu kadar sade ifade etmişti. Bugün burada bulunma sebebimiz, bugün adını veren adil yargılanma hakkı, sizlerin de bildiğiniz gibi ulusal ve uluslararası birçok metinle, usul kurallarıyla güvence altına alınmıştır. Ve esasında adil yargılanma hakkı yoksa adalet de yoktur. Bizleri bugün burada yan yana getirenin de aslında bu ortak fikre, ortak düşünceye sahip olmamız olduğuna inanıyorum ki zaten büromuz avukatları Ebru Timtik ve Aytaç Ünsal'ı ölüm orucu yapmaya iten de bu bilinçtir. Ancak bugün Ebru'nun uğruna yaşamını yitirdiği adil yargılanma hakkı Türkiye'de bizler için bambaşka bir anlama bürünmüş durumda. Bizim için adil yargılanma hakkı katledilen madencilerin, katledilmesine sebep olan şirketlerin cezasız kalması demek. Katledilen çocukların, katillerinin cezasız kalması demek. Avukat arkadaşlarımızın yıllarca tutsak kalması demek, sürgünde kalması demek. Avukat arkadaşlarımızın çocuklarının onlarsız büyümesi demek, onlardan ayrı kalması demek. Bu yüzden bambaşka bir anlama bürünmüş durumda bizim için. Türkiye'deki adil yargılanma hakkı ihlallerini anlatmam için burada yeterli zaman yok ama size iki isimden söz etmek istiyorum. Bugün Türkiye'de iki isim adil yargılanma hakkı talebiyle ölüm orucunda ve ölüm orucunun 170. gününü aşmış durumdalar. Aynı zamanda müvekkillerimde olan Gökhan Yıldırım ve Sibel Balaç Türkiye'de şu anda ölüm orucundalar ve seslerini duyurmaya çalışıyorlar. İşte tam bu örnek ve benzerleri nedeniyle adil yargılanma hakkı mücadelesinin tam da ortasından halkın demokratik hak arama yollarını açmasını umut ediyoruz ve aslında bunun için çabalıyoruz. Tüm bu mücadele hattını izlerken dünyanın her yerinden meslektaşlarımızla birlikte olduğumuzu, yüreğimizin birlikte attığını elbette ki hissediyoruz. Bugün burada Adil Yargılanma Hakkı Günü'nün ikincisi örgütleniyor. İlk etkinliği Ebru'nun da yaşamını yitirmesi nedeniyle zaten ortaya çıkan bu günün ilki Ebru'ya odaklanmıştı. Bu yıl ise burada 2 gündür Mısır'da yaşananları konuşuyoruz. Mısır'da yaşananlar tabii ki Türkiye ile farklılıkları var ama çokça da ortak noktası var benim gözlemlediğim kadarıyla. Halka hedef alan saldırılar çok ortak. Uzun ve keyfi tutuklamalar, yargısız infazlar, işkence, gözaltında kayıplar. Bunlar her iki ülkede de bizlerin mücadele ettiği temel başlıklar. Tabii ben bugün burada çok büyük bir onur yaşıyorum, çok büyük bir gurur yaşıyorum. Çünkü Ebru'nun adına birlikte halkın hukuk bürosunda çalıştığım, ondan bir sürü şey öğrendiğim ablam Ebru'nun adına bir ödül vermekten büyük onur ve gurur duyuyorum. Ve buradan da bu tartışmalardan, konuşmalardan anladığım çok da hak eden iki meslektaşıma takdim edeceğim bu ödülü. Az önce jürinin açıklamalarını dinledik. Bu ödül tam da Ebru'nun içine sinecek, onun da alkışlayacağı şekilde adil yargılanma hakkı için mücadele eden, bu hak uğruna mücadele ederken bedel ödeyen ve en nihayetinde de adil yargılanma hakkı ihlal edilmiş iki meslektaşıma veriliyor. Bugün her iki meslektaşımız da hapiste. O nedenle şimdi size bu ödülü göstermek istiyorum. Meslektaşlarımız hapiste olduğu için bugün onlara doğrudan takdim edemeyeceğiz bu ödülü. Ancak umuyorum ki bir gün mücadeleyle onlara yüz yüze takdim edebileceğiz bu ödülü diye düşünüyorum. Hepinizi Ebru Timtik ödülüne layık görülen meslektaşlarımızı alkışlamaya davet ediyorum. Ebru'nun ve Aytaç'ın adalet kavgasıyla hepinizi selamlıyorum. Er ya da geç biz kazanacağız.
Please consider that I am just the echo of the younger Ceren right now. So, good afternoon. First of all, I would like to greet you, all legal organizations and our colleagues, human rights organizations and rights defenders, and all colleagues who fight for the right to a fair trial. I greet you with the love that Ebru had. Yes, with the love that Ebru had, because Ebru was so full of love for the peoples of the world that it might surprise anyone who happened to meet her. She had traveled every inch of Turkey, fighting against every lawlessness and injustice she encountered. At the same time, she was also full of rage against anyone who oppressed and did injustice to the people she loved so much. This love and this rage it caused was exactly the reason why she laid her body to death in the face of injustices committed against herself, our office, and the people. Again, her own humble words can describe her the best way. Ebru said, "I want my name to go down in history, or at least in my modest biography, in a way that is unstained. I hope this is what will happen. I don't want anyone to say, she kneeled down, she ran away when the cross became too heavy to bear about me. In that respect, our record is set straight for the history and for our people. The answer you'll get will not change, even if you imprison us like you're currently doing or threaten us with life sentences. Neither any offers of personal gain or a bright future could change that. It has been so throughout history. Our debt books and our non-existent bank accounts are a proof of that. We are Marxists, we are Leninists, we are revolutionaries, we are socialists, and we are not after big glorious names. The life we lived is long enough to fill a blank page of history. As you know, The right to a fair trial is guaranteed by many national and international regulations and rules of procedure. And basically, if there is no right to a fair trial, there is no justice. I believe that what brings us together here today is our awareness of this fact. This awareness is also the source of power that Aytaç and Ebru had while they were fighting against injustice. Today, however, the right to a fair trial, for which Ebru lost her life, has a completely different meaning for us in Turkey. For us today, the absence of the right to a fair trial means the minors who were murdered and whose murderers remained unpunished. It means the children who were murdered and whose murderers remained unpunished. It means our lawyers, our colleagues who spend their lives in prison or in exile, and their children who has to grow up away from them. We do not have enough time to tell all these stories of the people whose right to a fair trial is being violated in Turkey. Let me just point out the following. Today in Turkey, Sibel Balaç and Gökhan Yıldırım have been on a death fast for more than 170 days for the right to a fair trial, and they are trying to make their voices heard. With this thought and awareness, we hope that the struggle for the right to a fair trial will open people's paths for democratic rights, and this is what we strive for. As we follow this line of struggle, we know that we are with our colleagues from all over the world and our hearts beat together. Today, we are organizing the second second International Fair Trial Day. The focus of the first event was the death of Ebru. Considering that her death also led to the announcement of this day, this year we are talking about what happened in Egypt for 2 days. What's going on in Egypt? Keeping in mind the differences between Turkey and Egypt, of course, is shockingly similar, considering the oppression and coercion practices targeting the people. Long and arbitrary arrests, extrajudicial killings, torture, disappearances under custody. These represent the main topics that we struggle against in both regions. Today, I am greatly honored to be here because I will present an award bearing the name of Ebru, a lawyer, a friend, and a sister I learned from and I worked with at the People's Law Office. To two of my colleagues whom I believe deserve this award. We listened to the statements of the jury. This award is given to two colleagues who fight for the right to a fair trial and pay a price while fighting for this right, and whose right to a fair trial has been violated in the end. I'm sure this would make Ebru very happy and she would applaud. Both Egyptian colleagues are in jail today. For this reason, other friends who are authorized on their behalf will accept the awards. This pure fact shows how much there is to fight for all of us. I invite all of you to give a standing ovation to our colleagues and friends who will now receive the Ebru Timtik Awards. We will continue to fight together until they are released. Once again, with the love Ebru had, and I greet you all with Ebru and Aytaç's fight for justice, and I am sure that we will win one day, today or tomorrow. Thank you.
Present the award winners. First, we will start with May El Sadani. She's representing Mohamed Al Bakir, and of course, as you know, we would like to have Mohamed Al Bakir with us too, but he's in prison for reasons that have been explained and that you know, and I'll explain to you in 2 days. But May will speak online about Mohamed Al Bakir.
Thank you. Hi, everyone. It's an absolute privilege to be here in your midst. My name is May Sadani, and I'm the Managing Director and Legal and Judicial Director of the Tahrir Institute for Middle East Policy. I wish more than anything that it wasn't me here on this virtual stage accepting the Ebru Timtik Award on behalf of a remarkable man who remains arbitrarily detained, and on behalf of a dedicated and loving family unable to join us at this gathering. Please don't get me wrong. It's the greatest honor, certainly one of the greatest honors of my career, to be here accepting this award on behalf of Egyptian human rights lawyer Mohammed al-Baqir. But I pray more than anything that he will be free, reunited with his family and his loved ones, and physically with all of you here at the next International Fair Trial Day in 2023. As a young human rights lawyer entering into the field, I would follow the cases of political prisoners quite closely. I would amplify on-the-ground campaigns like the Front to Defend Egypt's protesters, and I would parse through the documentation reports of civil society organizations. Across the board, I kept coming across the name of a human rights lawyer named Mohammed al-Baqir. There was something so special about him that came through across all his work. A bravery, a dedication, a principled commitment, a legal talent. Years later, in the summer of 2019, I was over the moon when Egypt's UPR would bring us together, providing us with the space to connect, convene, and brainstorm. I excitedly plotted all the different ways that I would learn from this remarkable attorney, and I daydreamt about the ways in which we would work together for years to come. My plans never came to fruition, however, because it would only be a matter of weeks until Mohammed would be unjustly arrested on September 29, 2019, while representing his client, activist and blogger Ala Abdel Fattah. Mohammed has remained in unjust detention ever since. In reprisal for his work as a human rights attorney and as founder and director of the Adala Center for Rights and Freedoms, Mohammed has been arrested, faced with arbitrary charges, questioned in the same case as his client. He's been held in years of pretrial detention pending multiple cases. He's been designated under the country's terrorist list in a case he's never even been questioned, a designation that subjects him to travel ban, asset freeze, and even potential disbarment. Most recently, he was sentenced by an emergency court to 4 years in a verdict for which there can be no judicial appeal, following a trial where his legal representatives were denied access to case files and denied the right to present a defense. A trial that took place even though the state of emergency had been brought to an end. In custody, Mohammed is held in a maximum security prison, and he's denied outdoor recreation time, access to books, a clock, and a mirror. These and many other serious violations of the right to a fair trial, they're paradigmatic of stories of countless others in unjust detention, including the tens of human rights lawyers who remain in prison in Egypt today. But these facts, as horrific as they are well documented and well reported on. They're all things that you would learn from a Google search about Mohammed, or from reading one of the many reports by reputable Egyptian and international organizations that have stood in solidarity with him and reported on his case since that fateful day in September 2019. Instead, I'd like to spend the remainder of my time telling you about who Mohammed is as a person, as a colleague, as a professional, as a partner, as a family member. In preparing these remarks, I had the pleasure of reading and listening to reflections from Mohammed's former colleagues, friends, and loved ones, and connecting with a few of them as well. In doing so, I sought to pull the pieces of a puzzle for you and paint a picture of who Mohammed is, what he has dedicated his life to, and how he has safeguarded the right to a fair trial across his career. I've never come across a figure as unifying or as widely loved as Mohammed al-Baqir. Across the board, across party, across ideology, everyone commented on Mohammed's compass and how for him, the only thing that matters is respect for people and respect for their rights. Mohammed has dedicated his life to representing individuals whose rights are being violated. And so you will not be surprised to learn that he's represented individuals from across the board. He's represented some of the most well-known political prisoners in Egypt, but he's also represented individuals whose names you and I may never know. As a result of his principled approach to the law, he's trusted by all, he's respected by all. His belief in justice is one grounded in humanity. And because he believes this is not just a job for him, it's a life calling, he was willing to accept risk as long as it aligned with his commitment to protecting this right. He's the type of person that when a colleague of his was traveling and stopped at the airport for lengthy questioning by state security, he insisted on waiting for her and refused to leave until she was okay, even though that subjected him to the same possible harm. You could be at a gathering say at a Ramadan iftar, a Ramadan dinner, and folks who vehemently disagreed with each other and would never tolerate being in the same place under any other circumstance would be there because Muhammad was present, because he had invited them. He was known to rescue stray animals and care for them. His home ended up becoming a home for rescued cats as well. He planted a garden in front of his office because he wanted to spread color and beauty, because he cares for the environment. He was described to me as a ball of energy. He was described to me as a ball of energy, someone who loves his work deeply. Not only has he supported so many defendants pro bono, but at times, this also meant spending from his own pocket. He's talented in the legal craft. Other lawyers spoke about their respect for his skills, particularly in representing and presenting rebuttal arguments. He served as a mentor to many of the next generation of researchers and lawyers now working in the human rights movement. Two different people from two different backgrounds said to me, Egypt's human rights movement is without, and it is without Adala. Friends talk to be loyal. He's you can count on. With you, comforting you in times of sadness and difficulty, but he'll also be there to join in your happiness, to celebrate your special occasion or birthday, to congratulate you when you have good news. He's the first to call. He loves his friends who spoke fondly of their memories drinking mint tea together. He's open-minded and accepting, and despite everything he's faced, he continues to smile and he tries his hardest to keep a positive spirit. He prefers motorcycles to cars. He loves to travel, and he's had happy memories in Europe and very, very happy memories in Morocco. And more than one friend made sure to highlight to me that he loves food. There's an amazing photo of him that many of you may have seen online, sitting on a bench by his beloved wife while eating ice cream. And he's looking at the cone so lovingly that I challenge each of you not to look at that photo and smile and appreciate his immense love for life. I could go on, but you get the picture. Hamad is a special soul. He's someone whose absence is felt deeply. And he's someone who Egyptian authorities should be celebrating and honoring. Someone who loves his country so much that he holds it to the highest standard. I want to thank the award selection committee behind the Ebru Timtik Award for recognizing Muhammad. I know that he will also be happy to learn that he is sharing this honor with fellow lawyer Haytham Hamadain, who he considers a dear friend and colleague. Recognizing the sacrifices and dedication of these individuals to protecting the right to a fair trial in Egypt is not only well-deserved, but it sends a strong and powerful message of solidarity with them, a reminder that Muhammad and Haytham have not been forgotten, and a recognition that human rights lawyers in Egypt continue to come under attack for their legal defense work, a trend that is not only alarming, but that threatens to eat away in a lasting manner at the rule of law, at access to justice, and at accountability. Thank you for this recognition, and thank you for your solidarity and advocacy.
The second award winner is also the prison lawyer, Mr. Haytham Hamadain, and he will be represented also by another very strong lawyer from Egypt, who is Mrs. Maimouna El Masri.
Thank you all. Okay, I do apologize that you have to see my face for the second day in sequence, but that's what the Egyptian regime do. So I find it a little bit hard to be receiving the Ebru Timtik Award on behalf of my dear friend and colleague Haytham Hamadain. It is hard because it shows the sad situation of human rights lawyers in authoritarian countries like Egypt and Turkey. Though both Sisi and Erdogan brag about their strong hold on their countries, and although they are trying to convince their people that they are enemies, but the truth is that they are two faces of the same coin. Both are dictators who want to silence their people, and their main enemy is human rights activists and defenders who uncover the real face. It is hard to see that a great heroine like Ebru Timtik had to give her life in her fight for freedom and against fascism. But her life didn't go in vain. She will always be a symbol of how human rights defenders are true to their principles and how brave she was. It is hard for me to be awarded to this award to a unique lawyer like Haytham, who has been in prison from May 2019. I was hoping that a miracle would happen and he would be released and would be the one who is delivering his speech, but still justice is lost in Egypt. I know Haytham before the revolution in 2008, while he was part of the defense front defending the workers and protesters of El Mahalla in the 6th of April strike in front of the State Security Court. And from that day, I have seen not only a brilliant lawyer who is very dedicated to his principles, but a very humble human being. And because of that, he was very successful in representing workers because they felt that he knows how they are living hard lives and how poverty is killing them slowly. And he worked with victims of tortures and refugees as well. But he never let his smile fades or his witty sense of humor disappears. As a son of a labor leader, he was the one who knew the agony of the working class the best. Haytham had been paying the price of believing in equality, law, and justice. This is why he had been subject to imprisonment several times. He was arrested on the 25th of January 2011 to be released before the Friday of Rage on the 28th of January. And on September 2013, after the 3rd of July coup, while he was going to support workers in Suez, to be released soon after. And on April 2016, he was arrested to be released in October the same year. That was not the final station in the road of his arrests. He was arrested in May 2018 and released in October 2018 to be free for only 7 months and to be arrested back in May 2019. And he's still in prison until now. And he was put under terrorism list to be banned from travel and to freeze his assets. Sometimes I feel that I'm lucky to be able to see him from behind the double-layered glass cell, just to see his smile that he's trying to force on his face to comfort us. We saw him last week in his pre-trial detention renewal session, and we were not able to tell him about the award because he wasn't allowed to be out of the cage and to stand in front of the judge. But sometimes I feel unlucky because I can see the trace of years of injustice on his face. Both Ebru and Haytham and Bakr as well, and the lawyers are victims of authoritarian regimes who prevented them from having fair trials. But I still believe that solidarity is our main weapon and that putting pressure on the authoritarian regimes to release the human rights defenders will pay off. I think if Haytham was present, he would have dedicated this award to the Egyptian workers, especially those who are in prison for trying to protect their rights, to the lawyers, other lawyers who are in prison like Ibrahim Mitwalli, Muhammad Ramadan, Huda Abdel Minam, Amr Imam, Amr Nuhan, Osama Bayoumi, and many others. To Ala Abdel Fattah on his 78th day of hunger strike, and tens of thousands of innocent Egyptians in prisons who are not well known to many. And I would like to end my word with one of Haytham's favorite chants. عايزين نخلق دنيا جديدة، دنيا الفقراء فيها سعيدة، دنيا الشارع فيها براح، فيها الناس قبل الأرباح. Which means we want to create a new world, a world where the poor people are happy, a world where the street is open and the people are more important than profits. One day do, Haytham, and rest in power, Ebru. Thank you all for choosing Haytham and Bakr. They are noble ambassadors of our situation in Egypt. Thank you all.
And I like to ask Sarah if you could show the award, because I don't know if you all saw it. Small, beautiful. So this is your awarded to Mr. Mohamed Al-Baki and Mr. Aitam Mohamed.
Thank you, everybody. My name is Sarah Chandler. I'm the Secretary to the Human Rights Commission of the FPE. And we have heard so much and we have educated ourselves, and we are committed to sharing that with as many people as we can and in whatever way we can. And we are committed to the principles of the International Fair Trials Day. And I'm going to go through them. There are 11 principles which we call upon ourselves to share and to ensure that our role in the international community, in whatever state we are engaged, will continue. We have heard from Mary Robinson that the states that do not denounce are complicit and colluding. We ourselves, if we do not denounce, will be complicit. So here are our principles. We call upon the Egyptian authorities to implement the following steps to ensure full protection of the right to a fair trial in the country and to create an environment enabling effective protection of the underlying principles. 1, with the African Charter, the principles and guidelines on fair trial, the Declaration on Freedom of Expression, and other instruments to which Egypt is a party and should observe. 2, immediately put an end to the harassment, arbitrary arrest, detention, prosecution, and sentencing of lawyers, judges, legal professionals, journalists, human rights defenders, opposition politicians, and individuals who express dissenting views regarding the government's action on fabricated charges aimed at preventing their legitimate activities and silencing them. 3, amend laws, including the counterterrorism law, media law, trade union law, cybercrime law, protest law, NGO law, and the Penal Code, in line with Egypt's constitutional obligations and international commitments to protect the right to a fair trial. 4, guarantee and respect the principle of presumption of innocence in all criminal investigations and prosecutions. 5, comply with international standards on prison conditions. 6, ratify the second optional protocol to the International Covenant on Civil and Political Rights, aiming at the abolition of the death penalty. 7, observe an immediate moratorium on death penalty pending abolishment. 8, halt the exercise of enforced disappearances, the commission of torture, and other practices that detract from the right to a fair trial. 8, take necessary legislative and other measures to ensure the independence and impartiality of the judiciary and end all practices constituting direct interference, pressure, or influence with respect to judicial conduct, including those from the executive. 9, stop any practices preventing enjoyment of the rights protected under international human rights treaties, such as freedom of expression, association, and peaceful assembly, and cease the practice of pursuing arbitrary prosecutions involving lengthy and punitive pre-trial detention, which prevent the exercise of these freedoms. And 11, create an open dialogue with the international oversight mechanisms and national and international NGOs to address and resolve the structural human rights issues in the country. And we call upon the international community to respond effectively to the deteriorating state of human rights and rule of law in Egypt, especially the lack of compliance with fair trial rights. and to increase its efforts to effectively address these issues with national and international stakeholders, including the Egyptian government. We go away today committed to these principles. We are joined with all of you who are online with us. That is our commitment. Thank you.
Dear friends, it was emotionally for every one of us to stay here. We're very happy to start in person this event. We think that this day will be improved in the future. And this is very important for everyone. We want to thank you, everyone of all. And we hope that in the next event will be more and more, because the Real Law Day are very important for everyone, not only for lawyers, but for all the citizens. Thank you, everyone, and see you next year. Bye.